We're going to try this afternoon to do something that certainly I haven't done before, and that is to present two types of dispute resolution and apply them to the same case to see what sort of outcome we get to the resolution of a dispute in arbitration and then in mediation. The two forms of dispute provide very different potential for parties, and we hope to illustrate that this afternoon. But as I say, it's a little bit of an experiment. It's something we haven't done before, and we hope that it will be interesting and informative for you. Most of the people on this platform have already been on the stage in sessions, so I'll be very quick in introducing. If I start with Francesco Lauro, Francesco this afternoon is playing the role of Charterer's advocate. Next to him is Leonardo Rondinella, who in real life is fleet manager and chief executive officer of LGR de Navigazione, but this afternoon is the same role, but for a company called Blue Chip Naples, who were the time charterers of a vessel called the Blue Chip Naples. Sorry, the company's called Deep Pocket Bulk Limited. Next to him is Peter Jago, a partner of MFB Solicitors, who this afternoon is the arbitrator appointed by the charterers for this dispute. On the other side of me is Christopher Moss, past president and committee member of the LMAA, and I'm sure very well known to all of you. He has been appointed as the owner's arbitrator in this arbitration. Next to him is Yanis Trifolis, who this afternoon is the guiding light, the principal of the owners of the Blue Chip Naples, and that's Blue Chip Shipping. And on my far left is David Pitlage, a partner of Hill Dickinson LLP, and he this afternoon is the advocate for the owners. We obviously, for reasons of time, have to curtail and make as brief as we can the history of how we got to where we were. In very broad terms, there is a dispute between the owners and charterers under a period time charter concerning the performance of the vessel during the course of the charter party. There is a legal issue, and it is based on a very topical recent case of the English High Court, and there is also one dispute of fact, which is why we have witnesses here. What would have happened in reality is that before this hearing, the parties would have exchanged written submissions, and indeed in this case, they would have also exchanged witness evidence and expert evidence in relation to the performance of the vessel. Now, we cannot take you into great detail about that. What I will do, though, is once the submissions start, is I will put up and occasionally change the slides that contain, number one, the clause that is relevant to this dispute, and number two, a very brief background of the most important facts of the case. We will then follow the arbitration with a mediation involving the same parties, the same dispute, and Jonathan Lux, who is a well-known mediator in London and based at Chambers in London, will take the role of mediator in that dispute. Now, what I can say at the beginning is that this case also illustrates the very different styles of approach to a case that you may see in an arbitration. I noticed before we came into the room this afternoon that the owners, David Pitlage and Yanis, were sitting down, talking very seriously about the case and looking at the papers. The Italian charterers, I noticed, Francesco Lauro was walking around with a glass of champagne in his hands and was looking very, very relaxed. So it will be interesting to see how these different approaches to arbitration and advocacy will see the parties through this afternoon. So enough of that, let us get on with the arbitration. And what would normally happen in the arbitration is we would briefly welcome the parties. My role in the arbitration is as third arbitrator, appointed by the two party-appointed arbitrators, because obviously when you have an oral hearing, you have to have 3 arbitrators in case the 2 appointed are unable to agree. So we will have welcomed the parties, we would have found out who is who and what their role is, and then we would open the case to the claimant, who here are the owners.